Court is calling 2022 CR 5698, State of Texas versus Armando Garcia. Can I have parties announced for the record for the state?
Ryan Grimmer for the state of Texas.
For the defense?
Daniel Rodriguez on behalf of Mr. Garcia.
Are you Armando Garcia? Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garcia, yes, one moment. I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it? Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Garcia, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places? Did you understand you're charged with felon in possession of a firearm? That's a third-degree felony, state. The range of punishment for that offense is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is asking that your punishment be assessed at 2 years in the prison, $500 fine probated? There's no application for deferred adjudication and the state recommends community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes.
State, is that the plea?
It is, Judge. However, we do have an additional condition that we also are TICing a misdemeanor out of the same incident under cause number 677470 out of County Court 5.
All right. Did you understand that to be the plea bargain agreement?
Yes, Your
Mr. Garcia, that's the plea bargain agreement? State?
It is, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation and 100 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Yes, ma'am. Fine.
State, any evidence?
Yes, Judge. State would offer State's Exhibit number 1.
No objection.
Showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Again, did you understand?
Quick legal pause. Hear this is a third-degree felony, which in Texas means real prison time is absolutely on the table. 2 to 10 years isn't a scare tactic. It's the actual range. And once the judge says it out loud, there's no walking that back.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Please, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we ask you follow the plea bargain. We also ask you follow the state's recommendations as well, Your Honor. This is a case where Although Mr. Garcia is a felon and didn't have the legal right to possess or use a firearm, he was doing so in order to protect his homestead. So we just ask you to take that into consideration and grant him the 2 years probation.
All right, Mr. Garcia, you are going to be drug tested today. If you're drug tested today, what are the results going to be?
It's gonna be kind of really dirty.
All right, you need to speak up. What is it going to be dirty for?
I'm methamphetamine.
All right. When's the last time you used?
219.
Okay, how often are you using?
I was using like twice a day. Not every day, but every other day.
Here's the thing. You shouldn't have custody of your child. And when I say have custody of your child, I mean, you shouldn't be the sole person being responsible for them because you're positive for meth. You understand that? So you're going to have to clean up your act. You're looking at me frowning when I say that.
No, because I'm listening to what you're saying, but I'm on here like I take care of my son, and I know what goes on around here and what he's doing, what you know what I mean.
Let me ask you a question. If you needed a babysitter for your child, I'm assuming you love your child, right? Do you love your child?
Yes, ma'am.
Would you walk through fire for your child?
Yes, ma'am.
Would you do everything you could to protect your child?
Yes, ma'am.
All right. Let's say you need a babysitter for your child and you asked me to babysit your child and you did a background check. I gave you references. Maybe I babysit children for Dan or Ryan, and they're like, oh, Stephanie Boyd is a great babysitter. She's the Black Mary Poppins. You will love her. You test me out with your child and you watch me how I interacted with your child and your child loves me. Please let her babysit me. That's who I want. And you say, Stephanie, your references are good. My child loves you. I'm going to hire you to.
This moment matters more than it sounds when the judge confirms the plea is knowing and voluntary. That's the court locking the door behind you. From here on out, there are very few exits, legally speaking.
Babysit them. When can you start? And I say immediately. And as I'm walking out the door, I feel a little guilty because there's something you don't know about me. So I turn around and I tell you, hey, look, I just want to tell you something. 2 days ago, I used meth. And I used meth probably like 2 days ago, but you saw me with your son. You know I'm present. Are you still going to hire me as your son's babysitter? Tell the truth and shame the devil.
I see what you're saying.
You're not going to hire me, right? So that's what you're doing right now. You're babysitting your child, and we're going to have to work on that. You understand? Do you understand?
Yes, ma'am.
Are you employed?
No, ma'am.
Why not?
I just lost my job like 2.5 weeks ago. I was working at J. Anthony's.
Mm-hmm.
I'm just going through a lot of harassment right now with my ex, and it's hard to do a lot of things without causing.
All right. Well, we choose the people we're in a relationship with, right? So this is what the court is going to do. The court is going to ask for proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. I'm going to want a TAP evaluation. I want a referral to felony drug court, and you need to not play games with felony drug court, and you need to let them know how often you're using meth. You understand? I'm going to want field visits 4 times per month. And probation, please check on his child. I mean, this is not CPS court, so I can't have your child removed from you, but somebody needs to check on your child. I'm going to want parenting classes with compadre y compadre. I'm going to want 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get that, but if you do, 40 of those hours will be waived. The remaining hours will be waived once you complete parenting classes. I'm going to want the UA hotline. And I'm going to want reporting 2 times per month until further notice. And the UA hotline is until further notice. And felony drug court should be able to get in touch with you by Monday. All right. Do you understand? Probation, is there anything else that he needs?
No.
Is there anything else that you need from me in order to be successful in this probation? Showing you what's entitled trial.
Notice how fast that happened. No live witnesses, no jury, no dramatic cross-examination. This is how plea deals end cases quietly, efficiently, and permanently. Would you feel comfortable pleading guilty without hearing a single witness testify?
Court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, then you need to speak to your attorney. Do you understand? And I'm sorry, probation, there's one other thing that needs to be added to that, to his conditions. One other thing that's going to be added. After today, there's not to be any unsupervised contact with minors until he tests negative. So until you test negative after today, there's not to be any unsupervised contact with minors until you test negative. You understand? With minors, people who are underage.
What does underage have to do with my case?
Because you're going to test positive for meth. You use meth. And right now I'm being told that you're taking care of a 10-year-old.
He's my son.
She's saying, well, start testing.
I don't, but it wasn't my choice to have him today. That's what I'm saying.
That's why I said after today, there's to be no unsupervised contact with minors. You can still see your son. And whether or not you see your son on your own without supervision depends completely on you. That means that you've got to stop using meth. Do you understand? If you are in Child Protective Services court right now, you know what they would do? They would have CPS worker go and pick up your son, because right now you are not an appropriate caregiver for him. Do you understand? And that's all on you. That's your fault. That's not your son's fault. You understand? All right, do better. All right, the court is calling the following CM numbers: 103132, 103133, 102906, 102907, 102905. State of Texas versus Raymond Cavazos. Can I have parties announced for the record for the state?
Ryan Grimmer for the state of Texas.
For the defense?
For Mr. Cavazos.
Mr. Cavazos, come down. All right. The defense is requesting a PR bond. State, are you in objection?
We are in objection, Judge.
All right. Any witnesses from either side?
No, Judge.
All right. Then the court will hear argument. State.
Judge, I think you have the PR bond paperwork up there, Judge. I don't recall exactly, but I think Mr. Cavazos has cases as well in California in which he had a couple of convictions for very similar offenses.
And the bombshell, the judge asked a question expecting honesty and got it. A dirty drug test instantly shifts this case from criminal punishment to child safety concerns. That changes everything.
What we're looking at here. In addition, back in 2004, he was placed on probation for a charge of forgery of a check, credit debit card abuse, and forgery of a check. In 2013, he was placed, he got a conviction and spent 20 days in jail for a theft case here in Bexar County. 2 years later, he also spent another 56 days in jail for a theft case. In this particular case, I believe we have 5 or 6 felonies pending. Essentially, he's caught trying to pass counterfeit money. They find him in a stolen vehicle with all kinds of documents that belong to other people. I think that his entire criminal history has been fraudulent type offenses, and that's not fitting of a PR bond. I think he currently has, you read him at the beginning, but he has a 400 to 200 gram heroin case. He has a fraud use case, a tampering with government records, a forgery of a government instrument, another fraud use case, another tampering of government records, and another forgery that are all pending at this time. We think a PR bond's not appropriate based on the fact that he continues to commit the same crime, and he has a bunch of them pending.
All right.
Judge, all of these basically arise out of, in 2 of the cases, they arise out of the same transactions. The 102, the cases beginning with the 102s all occurred on the same date, August the 19th, 2022. And also the cases that Mr. Groomer mentioned about the unauthorized use of forgery and the possession of controlled substance. Also, August the 19th, 2022, the passing, it was not attempted to pass any kind of counterfeit money. It was in his possession, but basically he was not attempting to do that. Judge, you have a PR bond report. PR bond report indicates his level of not being compliant is extremely low. I think he came back to the 4, which is low. He's always reported on all the cases that Mr. Groomer mentioned. He's never been a bond forfeiture. He's always appeared. The cases that he did receive conviction on were all completed satisfactorily. I believe that the purpose of the bonds are for him to appear. He has appeared. And obviously, by virtue of him having court-appointed counsel, he does not have the resources to be able to make these bonds. And so we're asking the court to place him on getting the PR bonds. The PR bond office has made a review of Mr. Cavazos. They're aware of his criminal history, but nevertheless recommended that he be granted a PR bond. Judge Herr reviewed it and approved that. So we're asking the court to give him the PR bonds on cause numbers 102905, 102906, 102907, 103132, and 103133.
All right, the court is going to deny the application for a PR bond. What I'm going to do though, Mr. Cavazos, I'm going to have this recalled in 30 days and see where the state is on their cases, whether it's indicted or not. If it's not indicted, then the court will strongly reconsider your request for a PR bond.
Can you get a bond reduction?
All right. We're not here for a bond reduction. We're just here for a PR bond. All right. So, Ms. Ferguson, can you put Mr. Cavazos on the docket in 30 days, please? And what date will that be?
Yeah.
All right. So we're going to come back on October 20th, Mr. Cavazos. And if there's no movement on your cases, then the court will strongly consider your application for a PR bond. Okay. All right. Thank you. Yes.
That babysitter analogy, that wasn't just a lecture, that was the judge reframing the entire case. This stopped being about guns or probation. This became about whether a child is safe, and judges take that personally. This is the line you never want crossed. The judge is openly saying CPS would remove the child if this were a different courtroom. That's not a threat, it's a warning. And at this point, the future is completely in the defendant's hands.